Several new laws were just passed affecting Florida HOAs and condos. The new laws went into effect July 1st, 2024. Today, we'll be highlighting what's important from those laws and what you need to know if you're on the board, involved in management, rent, or own in a Florida community association. The new laws concern 3 bills which improve governance, regulatory reform of community associations. Community managers, or CAMs, also saw some changes come from these new laws as well. The first is House Bill 59. HB 59 is about members getting copies of the governing documents. This bill requires HOAs to provide physical or digital copies of their rules, covenants, and all governing documents to every existing member by October 1st, 2024. Remember, this is just for HOAs and not condos. The copies of the governing documents can be provided electronically if the owner previously opted into receiving emails. A complete set of the rules, covenants, and any changes thereto needs to be posted to the association's website, viewable by a direct link without the need for a username or password for access. When you think about this law, I want you to think open public records. The second law that took effect July 1st is House Bill 1021. This is more affectionately known as the Condo 3.0 bill because it overhauled condos in a major way. When I say condos, I mean anything falling under Chapter 718 of the Florida statutes. If you're a Chapter 720 association, stay tuned. I have content for you in just a little bit. Under HB 1021, all condo board members are required to take at least 4 hours of state-approved educational credits with a licensed provider under the Department of Business and Professional Regulation, or the DBPR. Educational topics must be on the core areas of milestone inspections, structural reserve studies, fines, record keeping and transparency, and notice in meetings. New board members have 90 days to complete this requirement after taking office. The educational certificate is good for 7 years as long as the board member serves continuously without interruption. Each year, the board then must certify that they've satisfied this educational requirement by having taken the class. Yes, my firm will be teaching these classes for state-approved credit. Important note, if you took a board class at any point in the past, chances are you probably have to retake that class under this new law. However, there are certain exceptions. Overall, this law is good because it now provides a standardized benchmark for what board members need to know and what will be expected of them. Let's face it, we've had a lot happen in condo world since the last time educational requirements were looked at. So it's about time for this change. Just a quick mention on hurricanes. Hurricane protections and responsibilities are better defined for condos under 1021. This new law revises the requirements for installation of hurricane protections in the condominium building. It defines hurricane protection and also requires the covenant to delineate responsibilities of unit owners versus the association and cost of maintenance, repair, and replacement of hurricane protection. This would be for items like exterior doors, windows, or other openings. The law provides a uniform procedure for approval of hurricane protection and states that unit owners are not responsible for the cost of removal or reinstallation of hurricane protection if the removal is necessary to repair condo property. Not unit owner property, just condo property, like common elements. Okay, moving on, board meetings. Under the new law, condo boards must now meet once per quarter, that's 4 times per year. This is for condos that are 10 units or more. Gone are the days when a board could get away with just meeting once a year. No, a lot more face time is now required. The agendas for these quarterly meetings must contain an opportunity for unit owners to ask questions and get answers about the financials and status of projects. Right now, I know some of you are thinking, that's never going to happen. How on earth are we supposed to get anything done if everyone has something to say? Well, that's precisely the point. Oftentimes, I find participation is a problem. And agenda items can't pass because there's simply not enough people in attendance. Hopefully now that will all change with 1021. This minimum meeting requirement of 4 times a year is really crucial for members to know how their association is being run. Personally, I believe it will cut down on accusations of theft or mismanagement. Knowledge is power. Best practice tip. Right after your election, when the board holds its first operational meeting, make a schedule for at least these 4 meetings and stick to it. Calendar them right then and there, put them in your phone as calendar invites, and don't make excuses. Pay attention. The DBPR is now allowed to send spies to sit in on your meetings to ensure compliance with these laws. They'll probably have to identify themselves as being with the DBPR, but really folks, they're allowed to attend. Another change we saw with 1021 concerns condo websites. Now, condos of 25 units or more are required to have a website or mobile app. This is a reduction from the prior law we saw of 150 units or more needing websites. All condo websites must be up and running by January 1st, 2026. Now, what does that website have to have? Well, all covenants, rules, meeting minutes, agendas, notices, all contracts entered into by the association, bids for contracts, proposals, estimates, reserve studies within 45 days of receiving it. This is a new one. And any other standardized routine document like a welcome package or a new applicant form. The look back period for posting each item is going to depend on the issue itself. But the best practice tip I have for you is put it up as soon as you can. For example, meeting minutes might not be available until the next quarter when the board can actually meet again to approve them. But a reserve study, on the other hand, is required to go up within 45 days of receiving it. Associations must make a good faith attempt to obtain all records not within their possession already. That's going to be a hard one to comply with. Some management companies will hold files hostage for lack of payment, especially after they get let go. That's not allowed to happen anymore, now under 1021, but we'll see how that plays out. Associations are also required to organize the data in a considerate and logical manner. You can't play 52 pickup, like, oops, here's everything and good luck finding it. No, now you have to make a checklist of what's available and what's not, and keep that checklist for 7 years. I suppose job security would be in the data management field or app development to help all of these communities get online and organized. The focus of this bill is really to have everything out there in the open pretty close to the time it actually happens. Now, for the juicy stuff, criminal penalties. With HB 1021, we're looking at serious ramifications for violations of the statutes. Lawmakers have already said they will be prosecuting for issues like records-related violations, preparation of financial reports like cooking the books, conflicts of interest and kickbacks, voting offenses, and theft. While the severity of the punishment and classification of the crime will depend on each specific issue, the point is the behavior has now been criminalized. Civil fines and penalties like monetary sanctions for losing your professional license, all of that, can still apply on top of the criminal charges. This will be applicable to CAMs, your manager, and board members. If a board member is charged with just one of these offenses, just charged, not convicted, it warrants an automatic removal from office. Done. No questions asked, no lawsuits required, they're off the board, period. I highly recommend everyone read the full text of the new statutes for what specific activities are considered crimes. Right, next up, House Bill 1203. This is a very similar counterpart to HB 1021, except this time we're focused on HOAs. This is applicable to any community that falls under Chapter 720. This is going to be a property owners association, a masters association, townhomes, and traditional single-family homes. The key takeaways of 1203 are mostly the same as in 1021, but what I mean by that is it's the same 4-hour educational requirement in effect for all board members and HOAs. The same core areas for the course material are also required. That's going to be on the topics of milestone inspections, structural reserve studies, fines, record keeping and transparency, and notice in meetings. New board members will have 90 days to complete this requirement after taking office. Having taken the class means you've met the educational requirement for the next 7 years, as long as you serve on the board without interruption during that time. Then all you need to do is certify annually that you previously took the class. Criminal penalties and HOAs. HB 1203 criminalizes the same bad behavior for CAMs and board members that we looked at in 1021. Again, that's going to be civil penalties on top of criminal ones for things like repeated records violations, theft, embezzlement, cooking the books, voting offenses, ballot tampering, bribes, coercing a vote, kickbacks, conflicts of interest, benefiting in any personal way by convincing the association to use a vendor that you are somehow related to or affiliated with. Remember, all it takes to get automatically kicked off the board is a charge of any one of these offenses. Not necessarily a full-blown conviction is needed. Okay, websites for HOAs. Under 1203, a website or mobile app is now required for HOAs 100 units or more. This is a new requirement. HOAs didn't need websites before, but now they do. HOAs must have a live website by January 1st, 2025. That's right around the corner, folks. They must post to the website the following things: the covenants, rules, contracts, bids, educational certifications, minutes, agendas, notices, and any other routine document like a new member application. Okay, let's talk about fines and HOAs. Under 1203, fines become more difficult to stick. The key component of this revision requires written notice along with an opportunity to cure before the monetary fine is due. Previously, fines were largely permitted because of the simple fact that the issue had occurred. Now, the focus is on allowing the owner to fix the issue before hitting them in the wallet. Keep in mind that not all issues are fixable, and so you'll still see fines for the non-curable violations. For example, clean your dirty roof. That's a fixable issue by pressure washing. However, no parking on the street after midnight is not fixable because we can't go back in time and move the car if it's still there after midnight. Speaking of parking, 1203 now prohibits, I said prohibits, HOAs from restricting a homeowner or guest from parking a pickup truck or other personal vehicle or work vehicle in the owner's driveway or any other place the owner has a right to park. For example, a sales rep's lettered car for a roofing company, now allowed. A contractor's Ford F-150, also now allowed. Your neighbor's light-duty Toyota Tacoma pickup truck, also okay. An exception to this would be commercial vehicles. Those are still not allowed if an HOA has rules against them. Commercial vehicles are specifically defined in Florida. That's going to be anything over 26,000 pounds, more like a box truck, a motor home, a refrigerated cargo van. You'll know it when you see it. The law also prohibits fines or suspensions against HOA owners and their occupants for leaving trash cans out the curb less than 24 hours before or after the designated collection time. The law now prohibits fining for leaving holiday decor up for more than a week after written notice of a violation. Fun fact, 1203 says that HOAs cannot prohibit owners from growing vegetable gardens or hanging clotheslines as long as they are not readily visible from outside of the unit. The emphasis and trend now is a push for renewable energy and resources like air drying your clothes or growing your own food. That's okay until it looks like a bunch of rubbish in a flea market. There's always that one person who has to ruin it for everyone else. If denying an architectural change, the HOA must cite to the specific provision in the covenants supporting the denial, with special attention paid to allowing improvements on the interior of units not readily visible from outside. A key component of the covenant violations under 1203 focuses on not necessarily deeming a certain activity or action as a violation unless the activity or action is readily visible from the outside of the unit. The statute then goes on to say, what different scenarios would be of what is considered readily visible or not. Access to CAMs under 1203. Now, your manager must attend at least one board or members meeting in person per year. Zoom is great, but we need at least one meeting in the flesh. CAMs must inform the board and the association members of their contact info, including hours of availability and summary of duties. Any changes to those items must be updated within 14 days. The law provides increased educational requirements for CAMs regarding their frequency and number of credit hours each reporting cycle, and also mandates education on certain topics like record keeping. To sum it up, these three bills, House Bill 59, 1021, and 1203, make significant improvements in day-to-day operations for associations. These changes are good because they foster transparency and education. The standardization of educational credits for board members is key. The codification of criminal penalties now shows people in communities that this is serious business. Taking things that don't belong to you was always wrong, but only now did that language make its way into the condo and HOA statutes. Now it's got a prominent mention in the rule books. I think the driving reason for this is that given the post-Surfside mandates on structural reserves and the fact that condo living has gotten so much more expensive, we're dealing with a larger volume of money. Now we need checks and balances on people who oversee all of that money to make sure it actually gets to where it needs to go and not into someone's offshore bank account. So, just in case that was a temptation before, the legislature basically has now said, don't even think about it. I suppose the appropriate adage is, more money, more problems, right? Remember, this is a high-level overview and should not be considered as legal advice. Of course, feel free to contact us with any specific questions regarding compliance with the new regulations. Thanks everyone for watching. If you're a property manager or a board member and would like to learn more, please give us a call today. Our firm is here to assist you in every step of the way. If you found this content useful, don't forget to like and subscribe.